I'm David Lombardo, and this is WCNY's The Capitol Press Room, and we're checking in with Adam Fusco, a Republican election attorney who's representing gubernatorial candidate Bruce Blakeman in his case against the state's Public Campaign Finance Board after the Democratic majority ruled earlier this year to deny him access to matching funds as a result of a paperwork technicality. So, Adam, I guess for starters, why should the judiciary intervene in this case?
Well, so let's go back to how this whole thing unfolded. In December of 2025, Mr. Blakeman filed his paperwork with the Public Campaign Finance Board to be enrolled in the program. His program acceptance letter came back to him December 17th and said, "Hey, Bruce, congratulations. You are in the program. We're excited to see you here." Fast forward to February, Mr. Blakeman selects his running mate, Sheriff Todd Hood from Madison County, and away we go. Here we come, February 23rd. No mention from the Board of Elections or the Public Campaign Finance Board that there may be some perceived issue with their paperwork. Never did they do anything like notice Mr. Blakeman or Mr. Hood that they may be looking for something additional. Once the deadline to file passed on the 23rd, now all of a sudden here comes the PCFB on the 24th of February saying, hey, we think there's an issue because your, and not to get too technical, Dave, but your PCF 22, which is going to be a big part of this story, didn't acknowledge Sheriff Hood. Well, one, impossible to do that because Sheriff Hood wasn't selected as his running mate at the time they filed in December. But more importantly, the board failed to follow its own regulations. Under the rules and regs under the election law, the board had to promulgate a form for the two candidates to file jointly. This is all new, right? 4 years ago, neither gubernatorial candidate was in the Public Campaign Finance Program because this program didn't exist for that office, and there was no such thing as this joint filing. Now there's this requirement for a joint filing, but the board never produced the form. When the campaign filed its form, the board never said, hey, you might have an issue. So it's a very long-winded background to your question, which is why should the judiciary be involved? Because a state agency has messed up. This is not some minor thing. This is First Amendment free speech. This is the right to be able to run for an office and to access public funds. Now, obviously, Mr. Blakeman's opponent, not a part of the program, but does have some control over these agencies.
You feel like she does? I mean, my understanding is that the legislature is ultimately responsible for appointing, say, like the executive directors for the Democratic and Republican leadership posts with these boards.
That is so true when you're at the Board of Elections, but not the Public Campaign Finance Board.
Okay.
The Board of Elections, per the Constitution, has to have that equal makeup of Republicans and Democrats. It is truly bipartisan. The Public Campaign Finance Board actually holds a partisan advantage.
Oh, sure. But I mean, like the PCFB executive director, or whatever the title is, Brian Keegan, he is I think basically stems from the Assembly Democrats. He's their person on the board as opposed to being a veteran of the Hochul administration, the way we would have seen like Andrew Cuomo ensure that all his former staffers were in the important positions. So what makes you say this is like a Hochul-controlled decision?
Well, and I wouldn't go so far as to say it's a Hochul-controlled decision.
Leave that to the campaigns.
She certainly, yeah, right. I'll let them, the spokespeople deal with that. But she certainly has her fingers on this agency.
Okay.
Her appointee, former member Barb Lifton, was the tie-breaking vote at the board. So that is the governor's appointment that decides in a 4-3 vote that, hey, the Republican and conservative candidates opposing the governor aren't going to be eligible for public campaign financing, aren't going to be eligible for matching funds. Let's keep in mind that the Republicans in the legislature, when this program was first created as part of the, I believe, 2021 budget, didn't vote for this, right? Sort of conservative politics philosophy dictates that taxpayer-funded campaigns really don't dovetail with financial conservatism. But these are the rules.
Right.
And so when these are the rules of the road. This is what we have to play by. So this campaign finance program exists. My clients sought access. We're told, hey, you're in. We're happy to see you. And then once the time passed for them to change any of their paperwork, they were told, oh, by the way, you are going to be retroactively and unilaterally ejected from this program.
And in recent years, we had some legislation that set where these types of objections can be filed. So I'm guessing this is something that was filed in state Supreme Court in Albany County?
Your guess would be correct. As a matter of fact, I just left the Board of Elections, having served them with a copy of the lawsuit that was filed in Albany County Supreme Court last week, and the order to show cause was signed by the justice just this morning.
And does that geography play any meaningful impact from your eyes on how this case is going to be adjudicated? Or because something like this is probably going to end up before the state's top court, New York's Court of Appeals, does it matter to you where to file this? I mean, I imagine you're based in the Capital Region, so from that perspective, you're probably happy to be in state Supreme Court in Albany County.
Yeah, no knock on Suffolk or Erie County, but it's a little shorter drive here to the courthouse in Albany. The election law dictates there's only one place to file this type of case. It has to be in Albany County. We have a great bench here of learned justices. I'm not concerned about who the judge is going to be for this case because I know that on the law and the facts, we're right. And like you said, Dave, this case is going up the ladder. It'll go to the appellate division. Ultimately, it'll get to the Court of Appeals. So the trial court is just going to be the first step. But I would like to win there because it certainly makes the appeal that much easier.
So one of the things that we've heard as this issue is played out is a variety of lawmakers say, hey, when there's been issues with my filings with the Public Campaign Finance Board, they've reached out to me. They've proactively said, hey, let me help you navigate this. Here are some errors. Is that something that is going to be incorporated into your case at all?
Of course. One of the regulations for the board requires them to conduct outreach, both to campaigns that are in the Public Campaign Finance Program and those that have filed to have a campaign finance committee but aren't in the public program. Both of those require outreach from the board. Here, the board didn't provide any meaningful outreach to the Blakeman or Hood campaigns. They had day-to-day communications about things like, hey, your treasurer may need to sign this document, or we're looking for your initials here, or please send us a W-9 or a bank statement to show where deposits should be made. But never did they counsel any of my clients that, hey, there may be an issue with this paperwork, which is incumbent upon them, as it says right in the regulation. And then I'll go even a step further, Dave. The law says that when the BOE or the Public Campaign Finance Board gives advice, that is presumptively valid. Here on December 17th, the PCFB said to Bruce, congratulations, you're in the program. That was a certified board document. We relied upon that advice. My clients made choices as to how they wanted to raise money for this campaign by not going after those top dollar donors, by looking at those donors that would contribute, $250 or less so that they could seek that 6-to-1 match. So there was this strategy of going after these grassroots donors, relying upon the information that the board gave them. And now all of a sudden they're being told, hey, you're not getting matching funds. Yeah, it's in contract law, which, hey, if you got to breach a contract, still hire a real attorney, Dave. I'm just an elections attorney. But I believe that's called collateral estoppel or promissory reliance.
Well, I'll have to take your word on that one, but you're saying that the matching funds potential was something that informed their contribution strategy and they weren't going to go after big dollar donors? I mean, hearing that makes me think of some guy who might say, yeah, you can't fire me. I quit.
There's something to be said for that, but the campaign did intentionally seek donations under the $1,050 limit because they anticipated that they would be matched. Now here we are being told that it's not matched, and now they've got to decide whether to go after those contributions up to that roughly $20,000 limit or continue along the path that we've chosen, hoping that we'll be successful in court.
And that was Adam Fusco, a Republican election attorney who's representing GOP gubernatorial candidate Bruce Blakeman in his lawsuit against the state Public Campaign Finance Board. To hear more about the nuances of election law, check out our Insider Podcast Dispatches from Planet Albany, available wherever you download your favorite podcasts.
Fraud and lawsuit abuse raise car insurance costs for New Yorkers. Reforms are being proposed to mitigate their impact. But some Albany leaders want to keep the status quo. Information on these reforms is available at keepnewyorkaffordable.org.
Support for the Capitol Press Room is provided by New York State United Teachers, a statewide union of nearly 700,000 professionals in education and healthcare.